Canadians have the right to doctor-assisted suicide. That is the ruling of the Supreme Court of Canada. It is a historic step. And to talk about its implications, we have reached Stephen Fletcher. He is a Conservative member of Parliament and one of the many voices calling for change. Mr. Fletcher, what happens next?
The legislation could go through Parliament, through the Senate, between now and the summer. The problem is that there isn't a lot of legislative time. Mm-hmm. We got this budget, we got all these other bills, and then there's going to be, and we know there's an election on October 19th. So it's really up until the end of June where there's room for us to bring this forward. So it's conceivable it could go past the election, but then it becomes an election issue. And I'm not sure, now that we have clear direction from the Supreme Court, that, people want it to be an election issue. I think people would rather focus on the economy, job creation, public safety, Canada's role in the world, and so on.
I mean, you have, as I understand, a private member's bill that deals with this issue. I mean, do you foresee putting that forward before Parliament and expediting that?
Well, I have two bills, and one that deals with the actual criteria for physician-assisted death, and a second one that would allow for a reporting mechanism to keep track of what is going on and help collect the data for good public policy going forward. Mm-hmm. And that bill, a derivative of that, has been introduced into the Senate already. So I can see that that the bills, either in the House or in the Senate, could move forward quickly without too much difficulty. We can come up with a consensus based on the wishes of Canadians, fulfill the Supreme Court issue or directive, and allow for people to express their views and be counted, and have legislation in place before the next election. But we would have to move very quickly.
Mr. Fletcher, help me understand how you came to believe so strongly in this issue.
When I was 23, I hit a moose with my car that left me paralyzed from the neck down. I found myself on an intubator or intubated, mm-hmm. Tubes through the nose. My lungs had collapsed. They were suctioning the fluid from my lungs every few minutes, day in, day out, week after week, month after month. And it was what I call well-intentioned torture. Now, I was young. I had my whole life ahead of me. So I fought through that. But if I was 93 and that happened, mm-hmm. I wouldn't want to go through that. I wouldn't wish it on my worst enemy. And suffering happens. A lot of suffering happens. And there are situations where all the resources in the world can't make the situation better. Why in those situations should there not be an option? I would have found it a great deal of peace of mind to know that I would not end up drowning in my own phlegm.
Mr. Fletcher, in the wake of this court ruling, what is your message to Canadians?
The Supreme Court decision has another effect on the people of Canada, and that is it takes the taboo away a little bit about dealing or talking about end of life issues. Families, I hope now, will read their newspaper and talk around the kitchen table about what their wishes are under various circumstances, get a living will, and lay the foundation, because you never know what is going to happen, and it can save a lot of grief in the future. So by doing that, the Supreme Court has done Canada a great service, Canadians a great service, on that issue alone, by bringing attention to end-of-life issues, which touches us all eventually.